Salty Esquire. My name is Chad Ropes. I'm a licensed attorney in the state of California and your host for this show. Today's topic, public photography, civil rights or criminal activity. Let's get started. Smartphones are everywhere today. Almost all of these smartphones have high-powered cameras, including video cameras. Public photography has become a very hot legal issue recently. So let's talk about, do we have the right to take pictures in public? And if so, are there any limitations on that right? Well, I think most of us would agree, yes, we have a right to take pictures in a public place. Most of us may not understand why that is, but we believe we have that right. And we're correct. U.S. Constitution and the Bill of Rights, specifically the First Amendment, contain some provisions that are helpful in this case. The right to free speech and free expression. The right to free press. Both of those have been interpreted to allow private citizens to take photos and video in a public place. As with any right, there are limitations and exceptions. This one is included. In California, we have specific statutes that identify the limitations to your right to take pictures in a public place or in any place. Specifically, the California Penal Code has a couple provisions that can guide us in this case. The first one, we have some statutes that are commonly identified as invasion of privacy statutes. So what does invasion of privacy mean? Well, first, we have to determine whether people have an expectation of privacy in certain settings. The law seems clear in some settings, there is an absolute expectation of privacy. In other settings, there is not. For example, under the invasion of privacy laws in California, it would be illegal for somebody to use a telescope or some other electronic device to peer into someone's home and to spy on them. Furthermore, it would be illegal to use a camera to look up a woman's skirt or beneath her clothing for sexual gratification. In addition to that, it's illegal to record somebody in what you know is a private setting without their consent. These all seem pretty straightforward. They all involve a common trend of there has to be some right to privacy, some expectation of privacy. In addition to the invasion of privacy laws, California has other penal codes that apply to this issue, public photography. First one, can you audio record conversations? Well, that depends. What does it depend on? Where you are and who you're speaking to. For example, in California, we have what we call a two-party rule. Some states have different rules. In California, we require that if you're going to audio record a conversation, for example, a telephone conversation, you would have to notify the other party and get their consent. So both parties to the conversation would know that it's being recorded. That may also be true for conversations that are in a somewhat public area. For example, if there was a couple sitting in a park having a conversation between two people, and you were there and you are recording the park, could you record their conversation? It depends. First thing we have to look at is, would those people believe they have a reasonable expectation of privacy? Well, they are in a somewhat public setting, so maybe not. Maybe they are off in a corner by themselves. Maybe they are speaking softly so that no one could overhear them. there's a possibility that they could believe that that is a private conversation and that they would have that expectation of privacy. To be safe, if you are going to record a conversation that may be private, get their consent or don't record it. Are there any other limitations regarding recording in a public place? Doesn't appear like there are too many under California law, but there is an additional law that I think would be helpful. It is California Penal Code 148 subsection G. In general, California Penal Code 148 has nothing to do with public photography. It's actually a statute that prevents people from interfering with police activities. Obstruction, interference, delay a peace officer while they're performing their duties. However, subsection G of Penal Code 148 is a little bit different. What that section says is that it is not illegal for somebody to record the police or other public officials while they're in the course of their official duties. In addition, the person recording has to be in a place they have a legal right to be or in a public place. So why is this helpful? For one, it specifically allows citizens to record government officials. Why is that important? In order for citizens to hold government officials accountable, we have to have the ability to record their activities. This allows people to record what they believe is corruption from the government, inappropriate actions by police officers, and then to bring this information to the public sphere. Without having these protections, the police would be able to prevent private citizens from recording their duties. Laws pertaining to public photography are not important so that we could ensure that we can take pictures of our kids at a park or to photograph strangers on a sidewalk. They're important because it allows us to keep our government officials accountable. That's the whole purpose for California Penal Code 148 subsection G. It allows citizens to record police and other government officials to ensure their accountability. How else can we keep police accountable if we can't record what they're doing? Seems pretty straightforward, correct? As with many issues in the law, not necessarily. Looking at recent events, it appears there is some confusion regarding 148 subsection G. A few days ago, a public photographer was shot in the leg by a security guard while she was standing on a sidewalk recording. Doing a little bit of research for this episode, I came across numerous videos on YouTube. Some are titled Cop Block or Cop Watch. These generally are people that will go out and record police during a traffic stop or some other public interaction. There's also another set of videos called First Amendment Audits. Generally, these are citizens that will go to a government building or facility, stand in a public place, and record the facility or record government officials coming in and out of the facility. Again, both things that fall under California Penal Code 148G. Unfortunately, police don't follow this law. Many times, based on the videos that I observed, the police will come out and interrogate the photographers. They will attempt to stop the photography. They will ask to delete the footage. They will sometimes confiscate the cameras. In the most egregious cases, they will actually arrest the photographers for doing nothing but public photography. Clearly, there is a disconnect somewhere between what the law says and how the police are enforcing the laws. So what do we do about this? How do we resolve this problem? I don't have an answer for you. Possibly more education from law enforcement so that they understand how the law should be interpreted and enforced. Possibly we need some new laws, maybe some penalties for violating 148G. If you have any suggestions, please leave a comment. If you disagree with my opinion on this legal issue, leave a comment. If you found this information informative, please subscribe, hit a thumbs up. But remember, when it comes to legal issues, take everything you hear with a grain of salt.